Carbon pricing is here to stay in Canada. When the Trudeau government's Greenhouse Gas Pollution Pricing Act took effect in 2019, provinces like Alberta objected, saying it overstepped Ottawa's authority. But the Supreme Court disagreed, ruling 2 years later that climate change is a matter of national concern. It says the federal government has the right to set minimum carbon pricing standards for the sake of peace, order, and good government. So, what does the federal law actually do? It establishes a national framework for carbon pricing, whether from industrial emitters, such as the oil industry, or consumers at the pumps. If a province falls short of the national standards, Ottawa applies its own carbon price there, known as the backstop. Provinces can set their own policies to meet the standards, which can take a couple of forms: a cap-and-trade system or a straight carbon price. A cap-and-trade system sets a limit on the amount of carbon that companies are permitted to burn. That's the cap part. It also offers the option for companies to buy the right to burn more than their quota by purchasing allowances, also known as carbon credits, from companies that burn less. By doing this, they exchange their right to emit greenhouse gases. That's the trade part. The government makes money on those allowances because it auctions off a certain percentage on them, while providing free allowances to companies that face competitive pressures. A carbon price is different. It's a fee imposed on each ton of emissions from fossil fuels. Oil products such as gasoline and diesel, natural gas, and coal-fired electricity would fall under a new federal levy. That would mean everyone who buys a product that creates greenhouse gases would pay for their emissions. In theory, people will eventually cut their carbon use to avoid paying high prices. In that sense, both a carbon price and cap-and-trade have the same goal: to give companies and individuals a financial incentive to reduce their emissions.